Alex here with part 54 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That is the video of the detailed disclaimers and the underlying purpose of the series. Two things that I like to glaze over, however, are number one, not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that is because my access parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. My mindset at this point is, I remember, very negative. I didn't remember getting such a short order back from the judge in my case against the Secretary of State, but having seen that, it actually triggered a recollection. And this is the first time I really felt cheated by a judge. The closest I could come to it was the experience that I had with a domestic master in part, I believe it was part 8 or part 9 of the My Docket series. And at that point, I was frustrated because the judge didn't believe me, but at least I felt the judge thoroughly analyzed the case. In this particular situation, I remember not only losing the case, but the judge just not caring. And that was the impression that I got from it. I couldn't believe I had gotten such a short response from this judge. And this actually reminds me of another judge where I had almost the exact same situation. And that's a case that I brought against a landlord. But I'm sure now that this really frustrated me. And it triggered an appeal. I filed an appeal right after the order denying in this case because I felt that those statutes, the ones that I had mentioned throughout the series, specific to the confidential address program, I thought that those two different statutes were incompatible. The one statute that says you have to be an actual victim, and the other statute that says you're entitled to a fictitious address if you have a temporary restraining order. These two things don't mix together because you can get temporary restraining orders by just showing you might possibly one day be a victim. And that is not really consistent with the language of the act, and I do eventually win that, but at this point I haven't figured this out. I am going to file an appeal now, mainly because I feel cheated, and this is a good lesson for my viewers to not file appeals just because you feel cheated or wronged. File appeals because you can win. And by the time I get to the end of this appeal, I'm going to really drill home the idea that jurisdiction matters, specifically subject matter jurisdiction, which is what's going to come up in this case, and you can't get around it by arguing fairness. You just can't do it. The judge in this particular case lacks the jurisdiction needed to even make a decision on it. Now, in his order, he does make a decision, and what he has done isn't correct, it's wrong. However, the conclusion that he reached, which is that petition should be denied, ends up being the correct conclusion. And one of the things that the Supreme Court of Nevada will do is they will affirm a decision if it is wrong. However, the correct version of whatever that decision should have been leads to the same conclusion anyway. Now, at this point, actually, we can go ahead and take a look at what I have filed. Here we have the Notice of Appeal. This is the first appeal that I have ever filed in my life, and it's not going to be a victorious appeal, but it does at least teach me a little bit about the process. I'm going to really learn a whole lot more probably by the second or third appeal that I file. And I wouldn't be surprised if some of the documents in this appeal weren't filed properly, but at least I'll be able to go through them and indicate to my viewers what it was I did wrong. Like with my previous video, I didn't look at these documents ahead of time, so you'll get to see my reaction in real time as I go through them along with you. The Notice of Appeal, first thing I want to mention is this document does two things. The first thing that it does is it vests jurisdiction with the Supreme Court of Nevada. And what I mean by that is this is the document that gives them the power to even review your case. Without this document filed on time, it's not that the Supreme Court doesn't want to help you, it's that they are unable to help you. It's an incapability. It's a lack of authority or a lack of power. So this is the one document that you really have to get done Right. There are other documents that you could file in the Supreme Court that if they are filed incorrectly, the Supreme Court can give you an opportunity to correct them, file supplements, file corrections, etc. But the notice of appeal is jurisdictional, and it goes to their authority or power to even hear the case. So this is the one document you really don't want to mess around with. In Nevada, the notice of appeal only needs to identify the order that's being appealed, and if there are only specific portions of it that are being appealed, it's a good idea to identify that in the notice of appeal. And I'll explain why in a moment. But when you file this notice of appeal, not only does it vest the Supreme Court with the jurisdiction to hear your case, it also divests the district court with the jurisdiction to do anything on the issues that are being appealed. And that's kind of what I wanted to tie into with my earlier statement. If you are only going to be appealing a portion of an order and not the entire order, it's a good idea to identify that in the notice of appeal, because that lets the judge know in the lower court that they have only been divested of jurisdiction on that specific issue that you're appealing. And if you don't do that, it could cause some confusion. The judge might think you're appealing everything, and that judge, if you need to come back for some help in the lower court while your appeal is pending, which is very common in child custody actions, very, very common. If you need to come back to court on one of those issues, that judge will lack the authority to help you. There are ways to get around this, and I'm probably going to talk about, I've already talked about that in a video titled Jurisdiction Divested on Appeal. So go ahead and take a look at that video if you'd like to pick up on some of the details as to what I'm going into here. And also, if you would like to know how to get around the particular problem that I just mentioned. And same thing with the Supreme Court. If the district court is divested of jurisdiction, it's not that he or she, whoever the judge is, it's not that they are unable to, what I meant to say, it's not that they don't want to help you if you come back to court on another issue that you need their assistance on. Maybe you're filing like a motion to modify child support or child custody or something. It's that they are incapable of helping you. It's that you've basically stripped them of their power. You've stripped them of their authority and power to rule on those issues by filing your notice of appeal. So it's important to understand these little details. And the other thing that I want to mention is that not everything is appealable. And for the things that are not appealable, there are other ways to get relief. I'm not going to talk about that in this video because I already have 2 videos dedicated to that topic. The first of those videos is titled Notice of Appeal. And the second, wait a minute. Yeah, I think that's what I titled it, Notice of Appeal. And the second one is titled Writ Petitions. Oh, no, I didn't. Sorry, I didn't title it that. I titled it Filing an Appeal. I'm trying to keep these all in my head. Scrolling into this document, we see that I identify myself as representing myself, no attorney. And I also indicate that, what's this here? Statement of appeal. With regards to the district court's opinion, you don't have to put all this detail in here. I didn't need to do this. This is something that I could have done in the case appeal statement, which I think it's actually one of the documents we're going to go over. So describing details like this, you don't have to put this in the notice of appeal. In fact, you probably shouldn't put it in the notice of appeal. This is something that you can address in your case appeal statement instead. A little bit more detail goes into that document. This document is typically just a 1-page piece of paper saying, I appeal this specific order that was entered on this specific date with regards to this specific issue. So you'll see this in my subsequent notice of appeals that I filed. But in this one, I probably didn't know, and I wanted to be a little bit more detailed, so I provided additional detail to the court. Here we are. I'm indicating that I'm appealing the district court's decision to the Supreme Court of Nevada. Okay, that's correct as well. Yes, in your notice of appeal, you want to indicate who you are appealing to. In Nevada, this isn't very complicated. Justice and municipal court appeals go to the district courts, and district court appeals go to the Supreme Court. That's it. But other states, it's sometimes a little bit tricky. Other states might have multiple appeals courts. It may be a lot more complicated in your state, so make sure you understand the importance of identifying who you are appealing to. Some people who watch this video might point out that we have a court of appeals. It's true that we have a court of appeals in the state, but you don't appeal to the court of appeals. That never happens. You appeal to the Supreme Court of Nevada, and then they decide in the Supreme Court of Nevada whether or not they want to push your case down to the Court of Appeals. They call this a push-down model, and apparently other states do this as well. Here's my information, which indicates that this document doesn't contain the Social Security number. Going on to the next document here. We have the certificate of service by mailing. I am indicating under penalty of perjury that I have mailed the notice of appeal to the government's lawyer, Wayne Howell. And nothing much else about this document here. I could have included this in the notice of appeal, as I've mentioned this on previous occasions. I didn't have to file a separate document, but I haven't figured that out yet. I will eventually figure this out. I'm hoping by 2011, 2012, but we will see. Case appeal statement. This is the document I was talking about earlier. Now, this document was prepared by the clerk of the court, the clerk of the district court. In fact, they have a special clerk, they call it the Supreme Court clerk, that works down in the district court that does stuff like this. They communicate with the Supreme Court as they are required to by law and by rule. And an interesting thing in Nevada that probably doesn't apply in every other state, but in Nevada, the case appeal statement is ordinarily prepared by the party who's appealing, with one exception: proper person litigants. Litigants who are representing themselves do not have to prepare the case appeal statement. In fact, if I read the rules correctly, they're not supposed to. The case appeal statement is supposed to be prepared by the clerk of the district court where the notice of appeal was filed, anytime the person who is filing the appeal is a self-represented party. So this particular case appeal statement was prepared by a clerk, not by me. And these details that are provided are outlined in the rules of appellate procedure. So it's not like the clerk just kind of came up with the things they wanted to state on their own. There are a list of requirements in the rules of appellate procedure that state what has to be in the case appeal statement line by line. And that's what this clerk is complying with. I'm going to glaze over this unless something jumps out at me. So right now, it just looks like it identifies the parties. And no, nothing really jumps out at me. It's a pretty straightforward document. Feel free to take a look at it. And as with my previous documents, you can download them by clicking on the links down in the description below. And if you have a question, you can always post it down in the comments and I'll address that. Certificate of the clerk. This is just a routine document that is prepared by the clerk of the court that certifies that the documents were transmitted to the Supreme Court. I think that's what it's stating. The attached documents submitted electronically are copies of the original pleadings on file. And let's see what these are. Oh, it doesn't even show what the attachments are. It doesn't matter. It's just going to be the documents that we've all, gone over already in this case. Certificate of transmittal. So this is the document that certifies transmission electronically to the Supreme Court. Another one of those documents filed by the clerk. Doesn't really mean anything spectacular. And here we have the receipt from the Supreme Court of Nevada to the district court indicating that they have received the notice of appeal. In this particular situation, my filing fee has been waived, so this appeal was filed for free. Normally, I would have to pay a $250 filing fee and a $500 cost bond, but because I was able to get a fee waiver in this case, I didn't have to pay neither the filing fee nor the cost bond, and since I don't have an attorney, I don't have to pay attorney fees, so this appeal is going to be litigated for free. $0 in costs and $0 in fees. This also will open a case in the Supreme Court of Nevada, so I'm going to get a docket number in the Supreme Court, and we will be seeing some of the filings in the Supreme Court in my subsequent videos into my docket series. Going into the aftermath, I filed 2 of these documents, and I would have had to pay $750 in costs, but because of the fee waiver, I didn't. So I incurred $0 in costs. The government didn't file any of these documents, so they incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. The government would have probably spent maybe 5 minutes on the notice of appeal, probably just entering it into their computer. I doubt they would have cared to look any further into it, at least at this time. So 5 minutes for the notice of appeal. Certificate of service, same thing. Let's just say 5 minutes just to review to make sure that they were properly certified as served. And then we've got those documents. There's 4 different documents filed by the clerk. I would just say all 4 of those combined, another 5 minutes. So we're looking at 15 minutes in attorney fees for the government, which is going to come to $62.50. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.